Good afternoon, everyone. So I think we will start, hoping that other people will join us a bit later. So my name is Furkat Tishayev, and I will be moderating today's event in my capacity of Law and Advocacy Officer with the European Implementation Network. Today we are particularly proud to launch the 4th edition of the annual report entitled Justice Delayed, Justice Denied, which focuses on a highly topical and major issue, the respect of rule of law in European countries, and particularly in the European Union member states. The respect of the rule of law is, the assessment is done through the prism of the implementation performance concerning the judgments of the European Court of Human Rights and findings of the European Union Court of Justice by the respective European Union member states. I would like to introduce our speakers today, our distinguished panelists who will provide us with respective assessment of the implementation performance concerning the European Union Court of Justice and the European Court of Human Rights. So we have Julieta Biziuli, European Implementation Network Director, who has direct experience with the Council of Europe Human Rights System, working in various institutions, including the Registry of the European Court of Human Rights and the Department of the Execution of Judgments of the European Court. Julieta will focus accordingly on the implementation records of the European Union member states concerning the implementation of judgments of the European Court of Human Rights. Our second speaker is Ninot Seretelli, a program director and coordinator at Democracy Reporting International, who has extensive experience in academic research on judicial systems and compliance with rulings of the European Union Court of Justice, as well as experience in representing the Georgian government in international courts. She will be accordingly presenting similar assessment of the EU member states' compliance with rulings of the Court of Justice of the European Union. Those presentations will be followed by the institutional feedback kindly provided by Daniel Freud, who is a member of the European Parliament, representing group of the Greens, and sitting in several European Parliament committees, including the LIBE, the Committee on Civil Liberties, Justice and Home Affairs. After those interventions, our guests and online viewers will have the opportunity to engage in a dialogue, share their comments, and ask questions to our panelists. But before passing the floor to our speakers, I would like to share with you some background information concerning the purpose and impact of the report. As I mentioned earlier, this is the 4th report cycle that EAN carries out annually, with 3 last years in cooperation with DRI, which allowed us to extend the scope of research from the implementation of European Court's judgments to the implementation of the rulings of the Court of Justice of the European Union by its member states. The main objective of such reporting is to analyze the state of compliance with 2 European courts by the EU member states as one of the key indicators of the respect of rule of law in the European Union. The report also contributes to the European Union Commission's annual reporting cycle concerning the rule of law, generally speaking, by providing relevant data, its assessment and recommendations to the European Commission Rule of Law Unit. Noteworthy, such reporting has a direct impact at the EU level, as the European Commission refers to a country's implementation record when it comes to the judgments of the European Court of Human Rights as one of the indicators of their rule of law assessment and compliance. Furthermore, European Commission may also address a specific recommendation to a given country on the need to implement the European Court of Human Rights judgments. Similarly, we hope that the Council of Europe institutions, together with national authorities, will increasingly use our report in their exercise of their respective mandates and duties. And to complement these positive dynamics, I would like to highlight that today we have a record attendance, particularly online, which also illustrates the growing interests of the general public and the key stakeholders at the European institutions, national authorities, and civil societies to this very crucial and topical issue. Last but not least, I would like to mention that EIN and DRI expressed their gratitude to Stiftung Mercator for their continued support of that project and the publication of the report. Speaking of which, the report that you see today is a preview brief, and the fully fledged, the full report with all the annexes and detailed data will be published very soon, in a couple of days. Without further delay, I now pass the floor to our speakers, starting with Julieta, please.
Thank you very much, Furkat. Good evening, ladies and gentlemen, dear friends in the room, online, counterparts from the Council of Europe and from the European Union bodies, friends from the national delegations, from civil society. We thank you for being here. I know it is a very busy period for all of us, and you showing up in such big numbers means a lot to us. I will not delay much in going directly into the findings of the report, because Furkat made a very good introduction and overview of what is to follow. I just want to thank very much, of course, Nino Ceretelli, my colleague from Democracy Reporting International, who made the trip from Berlin for this launch today, but also Daniel Freund. In a very busy European Parliament week, you did cross the bridge to come respond institutionally to our findings, because this is the kind of also metaphoric bridges that we are seeking to keep fostering and building. Justice delayed and justice denied, number 3, is the 3rd edition of our common effort, as Furkat mentioned. For EIN is the 4th year that we have been monitoring the relevant situation. When we're talking about non-implementation, we also speak about delayed implementation. We will have adequately the possibility to speak about all these nuances. Why we started monitoring the situation several years ago. It became increasingly obvious to us that particular ECtHR judgments, I will be talking about the record concerning the European Court of Human Rights judgments, are central to the rule of law questions as per their thematic. And as a result, they generate some stumbling blocks that are difficult to overcome. These are often common. There are common concerns between the two jurisdictions, as they concern the very core of rights that are fundamental for the upholding of the rule of law, such as the independence of the judiciary, freedom of expression, other fundamental freedoms. But as time goes by and the backlogs of unimplemented cases in respect of other rights keep piling up, the backlogs keep growing. It has become increasingly obvious that resistance to the court's judgments, no matter the source thereof, we will again have adequate time to discuss that. Not all instances of resistance is a principled resistance. There can be other reasons behind it, but the overall result is that European forum's judgments are not respected or are not implemented in a timely manner that makes the systems not suffer under this backlog. Introducing the data, which always I think they create this kind of anticipation every year, but of course we will go much beyond that. We will break that down very much. Let's start with the key numbers, our key findings for this year. As you know, we have been focusing as EIN in 3 main indicators: the number of unimplemented leading judgments, so the snapshot of the current backlog of unimplemented cases, which for 2024, I have to specify that we will be talking about the situation up to end of December 2024. So in respect of this indicator, the number was 650 last year. The second indicator is the percentage of leading judgments from the last 10 years that await implementation. So at which rate the courts can, the national authorities can resolve within 10 years the judgments pronounced in their respect. And the third indicator, so this year, for last year, the figure was 45.7%. And the last indicator concerns the average time leading cases have not been implemented. How long it normally takes a state, or here collectively, for the EU states to fully resolve their leading judgments. And the number last year was 5 years and 4 months. A few methodological clarifications. What do these numbers say and what they do not say? As regards the first indicator, the numbers of pending judgments, the numbers are taken from the Committee of Ministers 2024 annual report. So if you compare the numbers, we are taking the same absolute figures as the basis for our further research. This number reflects, as I said, is the current picture snapshot of the overall stock of problems currently awaiting full solution. So here in respect of the first indicator, the timing is not an issue, does not come into play anyhow. The second indicator is the percentage of judgments rendered in the last decade that are still pending. This indicator, like the next one, is calculated, and we calculate it every year using data from the Council of Europe's ECtHR database. This indicator captures the state's global ability to effectively implement court judgments on the basis of two rule of thumb principles, which are very generic. We expect less systemic and complex problems to be able to be fully resolved within 5 years. It is a period of time that would justify the full resolution of a problem. For the more complex problems, the 10-year rule of thumb principle also applies. Anything that goes beyond that indicates some sort of either resistance or dysfunction of the system that blocks implementation that needs to be resolved. I need to be very to highlight that this indicator needs to be subject to very careful interpretation, and we do interpret it very carefully. We don't take it at face value, as I will explain later. This is because high or zero values may reflect different things. They may reflect recent inflows. So within this indicator fall also judgments that were only pronounced last year. But they can also not capture very old backlogs. So the rising number of leading judgments that keeps falling out of the scope of this judgment, which keeps rising also is not captured by this statistic. So as I will explain, there are several other qualitative considerations that are taken into account. As regards the average implementation time, again, we are using data we calculate the data using the Council of Europe's database. This captures again how long a jurisdiction typically needs to fully resolve the entire mix of its implementation challenges, no matter how standard or complex they may be. Again, this is assessed critically because unusually high or falling averages can be explained by the mix of very old, ongoing, and newly arrived leading cases. So I'm trying to say that the methodology has limitations, and we acknowledge them, and we also acknowledge the need for contextual adjustments. So on the left-hand side of the slide, you see the classification grid that instructs our analysis when we take into account the figures in respect of each indicator, which is uniform for all countries. On the right-hand side, you see the limits and the adjustments that I'm talking about. We do take into account, and I need to highlight that the majority of the cases pending implementation are often the subject of ongoing reforms. It does not mean that the 650 cases were frozen in time and no one ever worked on them, no one ever touched them. As regards, secondly, numerical data, these do not quantify the severity of violations or the complexity of reforms. Why is that? Because the Council of Europe system, the Committee of Ministers system itself for assessing progress cannot quantify this severity. This can only be taken into account into the qualitative refinement of our findings. We do take into account, for example, how many cases are pending under the enhanced procedure compared to the entire mix of cases that a country has to resolve. So what I'm trying to say is that the overall assessment, which will lead us to this year's ranking of the countries, is not subject to a uniform formula. It is very well anchored into the objective, quantitative data, but qualitative considerations inform our final assessment. And here we have this year's list. You can see that by applying these qualitative considerations, we come down to the list of implementers, ranking them from excellent, passing on to very good, good, moderate, moderately poor, problematic, and countries with facing a very serious problem. You will have time, I think, at least those of you who were subscribed online have received that, and you will have time to study those results. I will pass on to this comparative overview to see some of the main changes of last year, what changed in our map. So what changed is that on the grimmer side of things, for two countries, Portugal and Slovakia, there has been a downgrading in respect of the overall performance. So for Portugal, passing from moderate to moderately poor, and for Slovakia, passing from moderately poor to problematic, because my native Greece was feeling a bit lonely in that category, as you will see. On the bright side, we had 4 countries whose overall record improved. Those countries are Austria, Germany, Cyprus, and I'm missing one. I have to go back to have a look, and Finland, of course. So yes, so Austria and Finland passed from good to very good. Germany passed from moderate to good. And Cyprus passed from moderately poor to moderate. We will see why, or at least our conclusions, some partial conclusions that we can discuss with you about what brought about these changes. As said, this will need to be broken down much further, and the analysis has to go much deeper than that in order for the results to be credible and more easily understandable. The same 5 countries consistently qualify as the most struggling compliers in the last 2 or 3 reports, if I'm not mistaken. For the Council of Europe system, those are in alphabetical order. Always the countries here are presented in alphabetical order. It is Bulgaria, Hungary, Italy, Poland, and Romania. Those are common, as you will hear from Nino, for both jurisdictions. Italy makes the difference here in respect of the Council of Europe system. But again, even among these most struggling compliers, there are nuances to be made. So Romania remains the country with the biggest number of leading cases, which is 111. And this is important because this means that the country has a heavy workload, a heavy backlog of unresolved or not fully resolved problems, which burdens the country, but also the implementation mechanism. But if you compare it with Hungary, for example, which only has 47 leading judgments in terms of absolute numbers, the problem with Hungary is that 74% of those leading judgments from the last 10 years were still pending, which means that Romania, although it has more unresolved problems, it is engaging. There's better engagement, there's better movement, there's better mobility in terms of the cases. Hungary, with its 47 judgments, still raises, because of how much these problems are more or less stuck in time, raise more concerns about the rule of law situation. You will see Ireland in there, and here is where things start getting interesting, and the importance of indicators and how we interpret them becomes very important. Ireland is admittedly one of the best, most convention compliant states. If I'm not mistaken, I stand to be corrected if I'm wrong, but Ireland, throughout its history, it has only had 14 violations found in leading judgments. It means it's a very well-entrenched situation of respect for convention standards. The problem is that the 2 judgments that are pending in respect of Ireland have been pending for an average time of 2 years and 7 months, which begs the question, it's great that it is a convention-compliant jurisdiction, but if it were to find itself in a situation of an increased backlog, would the implementation mechanism be as efficient? Now, 8 states, you see them: Bulgaria, Hungary, Italy, Malta, Poland, Portugal, and Romania and Slovakia, have an over 50% 10-year non-implementation rate. We have other countries that have more. So Luxembourg has 67, if I'm not mistaken, but this is not statistically important, and this is why Luxembourg is not in there in that mix of states, because the 4 or 5, if I'm not mistaken, leading cases of Luxembourg came in only last year or the year before, so it's not indicative of a problem. 10 states, interestingly, and you can see which those states are, have cases pending implementation for more than 15 and up to 24 years. At least they had until at some point in 2025, because the case that was pending for 24 years was an Italian one, and it was closed in the course of 2025. This is what we're talking about when we say about problems that, if they remain unresolved for such a long time, create situations that we cannot explain in terms of the overall state of being, state of compliance. We cannot have as important, as structural as the problems might be and are in reality. There can be no conceivably problems that remain unresolved or with tails being unresolved for close to a quarter of a century. I mentioned the countries that changed category, and I'm passing now to the second layer of how our assessment is instructed. We have found that certain thematic trends, some of them being common in the 2 jurisdictions, are by their nature susceptible of generating bigger stumbling blocks. We have assessed, since last year we started assessing some of them. The first one, of course, since it's the rule of law we're talking about, is the independence and impartiality of the judiciary. Bulgaria, Hungary, and Poland remain the countries that present the biggest problems in respect of this indicator. Some developments are monitored in Romania and Spain still. In Poland, 9 out of 14 leading rule of law judgments that the Committee of Ministers is monitoring concerns this jurisdiction following the previous situation with the reforms that took place from before 2023. The country is currently, as we will all agree, a rule of law laboratory. Very many developments managed to fit into a calendar year that has affected both the Council of the Strasbourg and the Luxembourg jurisdictions. Reforms are ongoing and they take place in a highly polarized climate. Romania, the country had more pronounced rule of law problem following also reforms that have been more or less resolved. We still remain, there are some elements, some tales of the problems that are still persisting, as also civil society reports, but also as the cases that are pending before the court indicate. So we are monitoring, we're especially waiting for the Grand Chamber judgment in Danilets to see where the situation goes. Freedom of expression. Of course, freedom of expression is comes to the core again of concerns when we're talking about the upholding of the rule of law. It is interesting to see that the same 5 countries that are the worst, the most struggling implementers, also have all of them a freedom of expression problem, plus Greece, which is the immediately 6th member state. Several dozens, it is between 50 and 60 leading cases concerning at least half the EU member states are concerned by this problem. In general, even if we take Council of Europe member states or EU member states, more or less 10% of the backlog of the Committee of Ministers concern freedom of expression. Hungary and Italy are among the most struggling compliers in respect of free speech judgments. Hungary in terms of the number of leading judgments where freedom of expression has been a problem. Italy has 3 cases, but these cases require measures including decriminalization of defamation where reforms are not yet moving forward. My native Greece features here because of how all the relevant cases are. Katrami and Vasilakis pending since 2007-2008 respectively. Again, progress here in respect of Katrami, there has been a decriminalization of simple defamation, so again the cases are not stuck in time, but as regards Vasilakis and the SLAPS problem, which keeps growing in Greece, still the progress is missing, although the case will soon will have been pending for 20 years. Elements here that we will not have time to discuss thoroughly concern the type of judgments we receive from the court for supervision, or the Committee of Ministers receive from the court for supervision. So the court is yet to acknowledge SLAPS as the source of free speech violations. So the analysis of the court still, and we can discuss why, it relies very much on this classic distinction between facts and value judgments kind of cases. And this creates problems when we come to the execution level and we are dealing with a new kind of situation where the overall context that creates rule of law problems has moved towards the SLAPS direction, a much more generalized context, whereas the execution needs to happen on the basis of all type of defamation judgments. And this creates interesting dynamics. So we do consider the case of Stojanovic versus Croatia that was closed last year as a premature closure, exactly because SLAPS-related developments are underway, especially as regards the EU anti-SLAPP directive and its transposition. Unlike what happened in Gülfer-Predescu versus Romania, where the case remains open and the Committee of Ministers continues taking into account what is happening at EU level and with how the transposition of the EU anti-SLAPP legislation proceeds. As regards other rights in detention, of course, more than half of the EU member states are concerned in close to 40 pending leading cases. Some of the common themes: overcrowding, poor hygiene and sanitary conditions, inadequate medical care, lack of effective remedies, in some cases hierarchies in prison. Here we have an alarming situation in France where the overcrowding keeps rising. It's already at 133% and keeps rising. There are about 82,000 detainees for about 62,000 operating places. Grave concerns in Belgium and in Greece. In Greece in particular, again with many measures taken, new facilities being built, new legislation facilitating use of alternatives to detention, but still as a result of other negative reforms, the numbers keep rising, currently being at 114% of overcrowding, if I'm not mistaken. And the effective remedy, that another greatly welcomed development, still not giving results. Mental health and psychiatry was an issue that is very sensitive and very dear to our heart. It's monitoring. Last year we only focused on persons placed in mental health institutions and major concerns with their rights, systemic breaches in their rights, where Romania and Bulgaria are the leading countries with the most pronounced problems there, in particular Romania. But we did realize, and we opted for broadening the scope of our research this year, and we also looked into cases where severe shortcomings happen in upholding mental health patients' rights when the latter fall under the criminal justice system. Again, very vulnerable groups of persons. Among many other states, concerning situation in Italy with cases pending since 2020 and a new case under the enhanced supervision in 2024 in respect of Czechia. LGBTIQ plus rights present at least in Bulgaria, Croatia, Hungary, Lithuania, Poland and Romania. Common themes there being the absence of or deficient legal gender recognition procedures, with some positive trends in Romania, at least in terms of cooperation with the Council of Europe competent bodies, but also in terms of working groups considering legislation brought forward by civil society. So this means that some cooperation spirit is there, but the situation very much dire, especially in Lithuania, where the case has been pending with the Committee of Ministers expressing grave concern recently for more than 60 years, but also in Hungary and Bulgaria. The recognition and protection of same-sex relationships is another thematic. We had the Romanian case that we were monitoring already. Poland came into the picture this year, and the supervision will be enhanced by the new judgment that was handed out today by the CJEU. Effective investigations of homophobic crimes are mostly identified in non-EU member states, but again, the question is the problem not existent in EU member states? I have in a small box the human rights and the triple planetary crisis theme, which was we focused on for the first time together. Of course, the leading judgment here was the Klima Signorina judgment concerning a non-EU member state, but it was a crash test about how the member states will receive such judgments, which will be coming more and more often. It will be the next litmus test about the capacity of the system to generate responses. Also, not just in respect of climate change cases, but in respect of the other two factors of the triple planetary crisis, and there we have already cases monitored in respect of Italy. I will conclude very briefly by looking at the trends, because as I said, we have been monitoring the situation for 4 years now. And as you will see, there has been an increase in respect of all three indicators. We passed from 602 leading cases pending in 2021 to 650 in 2024. The 10-year implementation rate moved from 37.5% in 2021 to 45.7% last year, whereas the average time leading cases take to be fully implemented increased by a whole year between 2021 and 2024, passing from 4 years and 4 months to 5 years and 4 months. Why all these numbers are important? The very first thing we need we will not tire of mentioning again and again. This is not a simple linear trend. It does not mean that nothing happened and these judgments just kept increasing. These numbers kept increasing. There have been closures, a lot of work, new cases coming in, others closed. But the overall problem is that the Committee of Ministers has been closing in the last years considerably fewer leading cases than it has been receiving for supervision. It has also been easier to close newly delivered cases than older leading judgments that identify complex or structural problems. And also, although reforms are undoubtedly underway in almost all the cases, as said, we need a closed case. We need a case closed by final resolution to be sure that the same type of source of violation will not generate new violations. In light of this situation, we do need the Council of Europe competent bodies to be much more decisive in tapping into the potential of the procedural competencies to respond to flagrant instances of resistance. There are promising initiatives, and we very much welcome them. We have been part of some of them. We have been supporting them. These initiatives need to be boosted. So there has been an intensified cooperation to improve national implementation mechanisms. And this has produced results, but this has mostly been the case where lack of political will is not the primary obstacle. So the national implementation mechanisms are being reinforced constantly. There has been an excellent initiative of the creation of the Executive Coordinators Network. This needs to continue, very many cooperation activities. But when political will is a problem, then we don't have the level of responses is not where we need them. At national level, we need to acknowledge progress, and we need to see what those states did well. So what Finland did excellent in the last couple of years is to strengthen its national mechanism in a way that allowed it to close 9 long-standing judgments and to bring its backlog down to 1 last year. It was moderately poor, its overall record 2 years ago, and now it is very good. Another very good example is Czechia, and we're very happy to have the government agent with us in the room. What Czechia did well was, again, that it created a very robust implementation mechanism. This is one thing. But the second thing is that the mentality of the institution is such that allows it to move past a litigious approach towards a case once the case comes from implementation. Although it does an excellent job in defending the country's interests when litigating before the court, when the case comes for implementation, it's all about how to best resolve the situation immediately, taking measures without being asked, without needing to all this push for the measures. And this is what helped Czechia weather a very big influx of court judgments this year. A last example, and with this I will end, is the example of Lithuania in the case of Makate in 2024. Lithuania is generally a moderate complier with some important stumbling blocks, but it nevertheless gave us in 2024 the near perfect example of what effective implementation should look like. In the case of Makate, which is a case which concerns freedom of expression and the banning of a book for children covering homosexual relationships, between the rendering, the court handing down its judgment and the adoption of all the necessary measures, including a constitutional court judgment and legislative measures to rectify the violation, it all happened in 2 years' time. So, and this is a kind of begs the question again of why this worked in that situation and it cannot work in other situations in the same jurisdiction, but also beyond. So our overall recommendations, and with that I finish, although our common report is basically made with a view to providing recommendations to the EU bodies rather than those that my colleague will pronounce later, still are binding for both of us. Nevertheless, as our report is used as a tool more and more often also by the Council of Europe members and the member states, we do feel that it is useful to also have some recommendations towards the Council of Europe bodies. So as regards the Committee of Ministers, the body that is responsible for implementation, we need a much better, much more robust use of the full political toolbox available to the Committee of Ministers. Because if these measures are not used in that way, that leads to the trivialization of the members. There are newly introduced competencies as the complementary joint procedure between the Committee of Ministers, the Parliamentary Assembly and the Secretary General. It is no longer, and we hope to see the situation moving beyond this recourse to this potential being considered a radical measure in light of the present situation. Avoiding premature closure of complex groups before all underlying structural problems are demonstrably resolved. The Committee of Ministers has a very sui generis way of reading the court judgments. It is technical, it is compartmentalized often, but sometimes all cases do get closed while important reforms are underway. Applying political and diplomatic pressure in a consistent way across all thematic areas will be increasingly important. So for the moment, we do not have indications that this is not the case, but as specific thematics become more and more problematic for some member states, we will wait to see how and if the whole toolbox, political toolbox, will be applicable across thematics uniformly. In line with the Reykjavik summit, deep and structured engagement with ombuds institutions, NHRIs, equality bodies and NGOs, going beyond written Rule 9 submissions will be much welcome, as will be the increase of resources for execution work, especially for the Department for the Execution of Judgments, but also related cooperation projects. Why is that? Because a continuous increase of the court's budget has created this gap, because the court has been in a much better place to resolve decisively or to work towards the resolution of its own judicial backlog, but this must not undermine the implementation mechanism's capacity to reduce its own backlog. Towards the Secretary General, again, a procedural possibility, which is the possibility for the Secretary General to make use of Article 52 inquiries in states with entrenched non-implementation. So the Secretary General to ask questions about how the national laws allow the respect of Rule 46 of Article 46 of the Convention is something that we need to see. Again, this is not a radical solution. And as for the Commissioner for Human Rights, last but not least, among the various important means of action available to the Office of the Commissioner, which the Commissioner uses, targeted Rule 9 communications when addressing implementation matters within the broader context of the mandate is very important, and in our view it should be prioritized. Thank you very much.
Thank you so much, Julieta, for such an insightful, interesting and profound and complex assessment of the situation with the implementation of European Court's judgments and the dynamics over the last years. I think this information will generate many comments and questions from our public, but before passing to the second part, it would be good also to hear from Nino whether there are similar patterns concerning the implementation of the rulings of the EU Court of Justice, and what are the reasons for that, and what would be your recommendations to the EU institutions?
Thank you, thank you. Let's see if my presentation comes up. I'm very pleased to be able. I'm very pleased to be able to present this part of the study focused on the Court of Justice of the European Union and highlight some of the patterns that we see across the EU member states, some of which are very similar to what we see in the part of the study on the European Court of Human Rights. I'll just go into the substance already and tell you about our study. Essentially, we believe that compliance with the Court of Justice of the European Union's rulings is a rule of law issue, definitely irrespective of the substance of those rulings. However, for this particular study, we have concentrated on one particular subset of the CJEU rulings. These are those that are substantively related to the rule of law. And to understand what are those judgments, we have focused on the rule of law definition in the conditionality regulation, which highlights the elements such as legal certainty and prohibition against arbitrariness by the executive, as well as effective judicial protection. But more broadly, we have looked at the 4 areas covered by the European Commission's Rule of Law report. This includes justice systems, anti-corruption, media freedom and pluralism, and institutional checks and balances. So we have followed up rulings that fit into this definition, issued between the 1st of January 2019 and 1st of January 2025. And the assessments that you will find in our brief and subsequently the report are valid as of 1st of May 2025. These judgments have been include the rulings that were initiated through the Commission, but also preliminary rulings that came from the national courts. So because of the fact that there is no institutional knowledge on these rulings, especially in the part of the preliminary rulings, we had to ask national experts to follow up these rulings that we identified and trace judicial and political responses to these rulings. So you will see that our definition of compliance is quite broad. So it doesn't just cover referring courts, but we looked a lot more broadly in terms of institutional responses. We differentiate between 3 levels of compliance. In this part, we have more flexibility in this than our colleagues that are working on the ECtHR, since we create original data set in this. So we cover full compliance, but also partial compliance or incomplete adherence to the CJEU's prescriptions, and non-compliance, which is outright failure. So we look at the complete lack of action and resistance and reluctance, a lot of the time also sham reforms, which we believe don't generally alter the status quo. So my presentation for the rest of the time will be focused first on broader trends that we observe across the EU, and then I will go into the specific assessment of particular states and their performance, and finally finish with the recommendations that we have. So we traced 382 rule of law related rulings across 25 countries. Unfortunately, this year we don't have data for Czechia and Netherlands. So these rulings were issued between 1st of January 2019, as I said, to 1st of January 2025. And what you can see on the screen is that 223 rulings were fully complied with. That's 58%, over 58% of all rulings, which is good news. But at the same time, we see and observe partial compliance in over 25% of the rulings, that's 98, and non-compliance with respect to 35 rulings, which are around 9%. We have another category where there's no information in the public domain about compliance, but there's also no evidence of full compliance. So we are monitoring those 26 cases closely. So you can see that 133 rulings out of all the rulings that we traced, 382, over 1/3 is not yet complied with. It would be interesting to see who is responsible for this, because we have good compliers, but also not so good and problematic compliers as well. So it's important to know that partial compliance and non-compliance per se is not really a bad news. So it may be more or less problematic depending upon how much time has passed since the issuance of the CJEU ruling. So immediately after the ruling, obviously non-compliance is not so problematic, and partial compliance may be good news. So we decided to look at how long it takes to the states to comply, to highlight some of the significant delays that we observed. And we found that out of 133 rulings, 83 or 62%, 62.4 have been delayed compliance for 2 years or more, sometimes longer, and then the rest, which also we keep an eye on in the subsequent years, are not that significantly delayed. So if we compare to our last year's data and our this year's data, to put it simply, to spare you from detailed reading of these visuals, we don't see significant change in the overall picture. So there's a similar picture. There have been some modest improvements. We have, however, no substantial shift. So share fully complied with rulings remains around half. Rose maybe from 55 to 58%, and the proportion of partially complied with rulings is stable, a bit increased from 24 to 25.4%, and then proportion of non-complied with rulings came down to 9% from a little over 10%. So there's slight progress, which is driven by some isolated improvements. For example, with Poland, a couple of judgments have been complied with Portugal, with Ireland, but overall patterns have largely remained unchanged. So partial compliance is one of the trends that we find particularly problematic, especially where referring courts ensure case-level compliance, but then we see reluctance and resistance to systemic change. And we see again that the portion of the delayed compliance is quite high. What is causing this kind of significant delays? When we looked at the data, we saw that there are two categories of barriers that are cutting across different types of compliers. So we have political resistance, political deadlock often, as we saw in Poland also in terms of moving forward with legislative change, as well as executive reluctance, which results in fragmented or delayed reforms. And then we have the second problematic tendency with the judicial resistance in some of the countries, which then hinders national courts' application of EU law and results in a very mixed judicial practice and lack of uniformity. But there's a variation in terms of how problematic that is, depending upon how systemic such a resistance is and to what degree it's government orchestrated or not. So now we go down to who is responsible actually for the rulings that are not yet complied with. And similarly, we have similar methodology to our colleagues in that we see a variation in state performance, and states ranging from excellent compliers, in this case Ireland, to problematic compliers. In the marked, we have color-coded, so it's easy to kind of read. We have problematic compliers, Romania, Poland, Hungary, and Bulgaria, which very close to the bottom part of the ranking for the ECtHR as well. In between, we have three categories, with Luxembourg, for example, example of good complier, and then we have moderate compliers, Germany, Austria, Portugal, Estonia, Italy, and Spain. And then we have several poor compliers, including Belgium and Slovakia. So to understand and explain why the states ended up in where they are, we also present our methodology. It's probably easy to understand in that we have state is placed based on the proportion between full compliance, partial compliance, and non-compliance. So with excellent compliers, we see over 90% of rulings fully complied with, and very low percentages of partial compliance and non-compliance. And then correspondingly, with good compliers, there's a lower percentage of full compliance and higher percentages of partial and non-compliance. The same logic applies as we move down the a list of the categories of compliers. However, we have additional categories or factors that we included to place ultimately a state in a particular category. So these are a few factors that are triggering downgrade include significant delays and high non-compliance rates. So, for example, if a state would be in the moderate complier category, otherwise, based on these three parameters of percentages of full, partial, and non-compliance, we additionally look at the significant delays and high non-compliance rates, and the state may end up in a poor complier category as a result. And I'll give you a few examples of that later on. We also factored small case numbers. There are a few countries that I have not mentioned here because rule of law related rulings are not many in those countries, one or two, and then we are not able to make any statistically significant kind of conclusions or broader arguments. This includes Malta, Cyprus, and several others. In this, and you'll find more details in our brief as well. So just to give you a couple of examples more, for example, Austria, moderate complier, it has 69% of fully complied with rulings. And this fits the range. 50 to 69 is for the moderate complier category, and then they have around 30% of partial compliance, which is 11 rulings, and rather low percentage of non-compliance. So we find partial compliance percentage problematic still, but it does fit the moderate complier category. Also, there are some delays, but not as significant as in other states. So ultimately, moderate complier is the category for where it fits. However, to give you an example of downgrade, we have Belgium, which has the full compliance that fits the range of the moderate complier because it's between 50 and 69. But because of the significant delays in compliance, they comply out of 11 out of 12 are not yet complied with. So that causes a downgrade into the poor complier category, while they would otherwise be in moderate complier category. Similar thinking applies to Romania and Poland, which are now problematic complier category, even though they fit the poor complier category, which is one higher. So we have Romania, which has 47% of fully complied with rulings, but because many of the pending rulings are pending for a while, and these are justice system related rulings, according to our experts, then it ended up being downgraded. In the same way with Poland, we saw some progress with Poland in terms of finding creative solutions to get around the political deadlock and implement some of the rulings, but still overall situation, the systemic solutions are lacking, which results in high percentage of the delayed rulings. Bulgaria, it's not controversial. They have one of the smallest percentages of the fully complied with rulings and very high percentages of partial and non-compliance and significant delays. So there was no controversy that it would fit into the problematic complier category. Just a brief visualization for you to see the red and sort of beige colors are the marking partial and non-compliance, and the gray one visualizes essentially the delays. So you can see how what kind of portion of visually see what kind of portion of the rulings are really delayed out of all rulings that are not yet complied with. Here, two states are interesting. Hungary, for example, where we see significant delays. Almost all rulings are delayed that are not yet complied with. The same goes for Belgium, and there are some other countries where the numbers are not so high, but whatever is pending for a while. This applies to Portugal, to Germany. So some of the countries that fit with the moderate complier category, even those are pending. So the numbers look like this for the delayed compliance. So we have Bulgaria with the highest numbers numerically, and then Austria and Hungary as well, and Belgium. So, but with some countries, the numbers are rather low, but at the same time, it also means that this is stubborn compliance, which has been pending for a while. Yes, so this is how our country profiles would look like when, when we publish them, so that we trace each and every ruling and also do a thematic breakdown of the rulings and do the key takeaways and trace all the partial and non-complied rulings as well. Thematically, we have four key categories that our judgments fall into. Most prominent are access to justice and judicial independence, and then asylum and migration, even though a lot of this has to do also with justice issues. So, for example, Austria has very good record overall, but just asylum and migration related rulings are really delayed. And then data access and retention, we have this in Bulgaria, France, Austria, so issues with this security versus privacy dilemma. So since I really want to move towards the recommendations part of it, really briefly going through them. Portion of our recommendations is directed to the European Commission and broadly European Union institutions. So with the European Commission, we would want to see the CJEU rulings, compliance with CJEU rulings being made part of the core metric in the assessment in the rule of law report in the same way as it is with the ECtHR. And we are very happy to see that the ECtHR data made it into the ruling and hopefully this remains like that. And we would also call for systematic issuance of tailored country-specific recommendations based on the ECtHR and CJEU implementation records in the rule of law report, with particular focus on the chronic underperformers, Bulgaria, Hungary, Poland, and Romania. This should be tied essentially to the state performance rather than being random, because that would help also Commission increase the legitimacy of its choices when it makes such choices in terms of recommendations. Another call is to create public scoreboard, which would follow up and track the CJEU and the ECtHR rulings, but probably with the CJEU is a greater need, including in terms of preliminary rulings. And final few points about the use of the enforcement tools more decisively in cases of persistent non-implementation through imposition of fines or budgetary conditionality. We have seen that it wasn't very effective with Hungary, so our message probably would be that the costs of non-compliance should be high enough for it to incentivize the state to take action. Then overall, another recommendation has to do with making the implementation a priority topic, supporting pro-reform compliance communities, and finally create or adapt the existing funding programs, including SERVE, to support implementation-oriented work by the civil society organizations as well. So I'll stop here.
Thank you very much, Nino, and thank you for both speakers. I think it's really interesting and surprising to see how the information which is exposed in almost 200 pages have been efficiently and concisely packed within less than an hour. Unfortunately, Daniel has to leave a little bit earlier today, so without further delay, I will pass the floor to Daniel, and it would be really interesting to see your feedback on the key findings of the report.
Thank you. Thanks so much for this very detailed presentation. I think it's good to see, particularly the maps that you have made in a way, boiling down the rule of law crisis in the European Union, and what also me as a member of the European Parliament, what I see in the Commission rule of law report, in all the information that we receive, that it is very close to what you can also see in the non-implementation of the rulings. I mean, we have just today around lunchtime voted the latest edition of our report on Hungary, updating the further deterioration of what's going on in the country in the last 3 years. You've already touched upon some of the elements, of how we're trying to push the other EU institutions to do more about this, freezing the funding, taking the voting rights away, using infringement tools, and so on. And one thing that really strikes me, I have to say, given that from our point of view, really the crisis in Hungary is the gravest among the EU member states, is that we now have an example. There was a video released by Viktor Orban, I think about 2-3 days ago, where he is now turning the non-implementation of ECJ judgments into advertising for tourism in the country. He's basically saying, look, we don't apply EU asylum law, come visit Hungary. This is where we have come. So not only is, in a way, the data that you show and how, how many judgments, how long it takes and stuff, he is now turning that around and trying to make this a selling point for the country that he is not implementing. That tells you something about how far we have come in this crisis and how we need to be more decisive, It has taken way too long. 15 years now of these attacks on the rule of law, on democracy, on fundamental rights in the EU. And, the Article 7 procedure has been ongoing for 7 years. The money freeze started 3 years ago, but still, member states are reluctant to actually act. Why are we still sending any funding to the country when these funds are so systematically misused, stolen, and so on? When judgments are so systematically ignored, why are we not taking more decisive steps? And I think, you have also touched upon the case of Poland, and I think it is an interesting one because to some degree, there was always some parallel in the approach, particularly of the EU institutions, to Hungary and Poland, and I think I would argue that to some degree, we have definitely had more success in the case of Poland. The change of government has brought about, higher compliance with some of the rulings, but also, there were some actual reform efforts with all the difficulties of president not signing certain legal decisions, but joining the European Public Prosecutor, no longer, illegally appointing judges and so on is definitely progress. But it also shows you that, damage that has been done in the area of rule of law, compliance with rulings over 8 years is not something that is easily remedied within a short period of time, even if there is the full willingness of the competent minister, of the government as a whole, I would say. And I think there are some lessons learned from that also for other member states. We all know what the polling in Hungary is at the moment. If the election in April next year goes the way that a majority of us in the European Parliament hopes it will go, there will be a formidable challenge for a new government to try to repair the damage that has been done there. So this will keep us busy. We also see that when it comes to the majorities, it's not necessarily getting easier, neither in the European Parliament nor in the Council. And I think there is a real risk that we might lose at some point in the next couple of years, even the qualified majority in the Council that is needed, for example, for the rule of law conditionality. On all these Article 7 things, we see how far away we are. We don't even have the 4/5 majority as we speak in the Council to take a next step in that. This reluctance really of member states' governments to take that seriously, that a rule of law situation in another member state is not just something that concerns the citizens or people in that member state, but when EU values, when judgments of courts in a way no longer apply in part of the union, this is a problem for the entire union, for all EU citizens, for all governments, and so this really needs to be taken more seriously and not just a this is a problem that Hungarian voters or Hungarian citizens somehow need to deal with. But for everyone else, they're out of this. I don't think that the overall rule of law situation, the overall functioning of our EU institutions, and I think this applies partly also to the Council of Europe, can function this way. So if we want to preserve the system, if we want to uphold the ECJ and the European Court of Human Rights as institutions that function and that preserve our rule of law, our democracy, our fundamental rights, then I think we urgently have to change our approach to these questions. And I think the report that we have seen today is a very valuable input in that context. So thank you very much.
Thank you. Thank you so much, Daniel, for confirming the overall state of the implementation of the judgments of the European courts and illustrating the magnitude of the problem. I don't know if you have an immediate reaction to that, or otherwise we can pass to the Q&A session.
We can pass and then we will address.
Yeah, okay.
Just very quickly to thank you very much for this input. For me, this risk as we see this shifts in governments and the risk of losing the qualified majority that is required to pass some of the measures is a question of great concern, and it puts into question how the toolkit of the European Union institutions, which is much stronger than that of the Council of Europe, which is much more political and diplomatic in nature, how can this be upheld? So a lot to think about and to discuss there. But I would suggest that, especially if there's some question for Mr. Freund, you proceed to those, as we will need to release him soon. From the persons in the room, but also from online, and I see Claire Ovey who wants to take the floor.
Thank you very much. So Claire Ovey, Director of Human Rights at the Council of Europe. I just want to say, because I have to leave in a minute, and I just really wanted to thank you all for such interesting and very well balanced as well presentations, and I look forward to reading the reports as well. Thank you very much.
Thank you so much. Any further questions, especially online? Do we have something, Vincent? No, we don't have so far. Vincent, no questions online so far. Okay, well, I guess, yeah. Thank you again, Daniel, for your time, and we will continue the discussion. Thank you. All right, now so we can pass to the second part of our event, which is the open discussion, Q&A, comments on the key findings, on the tendencies, or on the recommendations. So the floor is open. Online, Vincent, can I please come here? So online questions are supposed to be, but they're
yes, we can give some time, especially to the colleagues online, to potentially come up with some questions. We understand that it is packed with information, what we just presented to you. We will have time also in a few days with the launch of the full report, because as I said, now we're giving you this exclusive brief over what will be soon revealed in 200 pages. So we will have the time also for advocacy debates. I just wanted to say, as people, potentially our colleagues online as well, from the European Union institutions that I know are following also, we would very much welcome your comments if you have them, but also our colleagues from civil society, if they have something to ask, although they have been the driving force behind a lot of information. They have been very helpful in providing us with a kind of qualitative qualitative assessments we need, because we are not present in the member states, in the field, in the member states. So if you have questions, please come forward. I just wanted to say that it has been a long journey for us. It has been a long journey to convince also the European institutions that non-implementation is a systemic problem that needs to be tackled at the same time across the two jurisdictions in order to have viable solutions. It has been an effort. We very much thank also the rule of law unit for the vision to grasp the problem as such, and to start looking into the matters of non-implementation at the Strasbourg level also as a rule of law matter. It is important that we move beyond the barriers that the two jurisdictions form. I think that at this level, and this is a recommendation, Nino, that it did not make the final cut, but I think it is something we can consider for the future, because there are increased debates also across jurisdictions. There's much strengthened, enhanced cooperation between the Council of Europe institutions and the European Union competent institutions, but these stop or reach their limits when we go to the core of talking competencies. And of course, what we are saying is not that the European Union bodies will monitor implementation of Strasbourg Court judgments. We're not saying that. We're saying that the body of evidence about the magnitude of the problem is so overwhelming now that this can no longer be ignored. And this somehow needs to translate into meaningful action that can be taken also at EU level to tackle basically the same problems. This is, for me, a main message to be passed. I don't know if you agree, Nino.
Yeah, I do definitely agree. I think it's important that these two studies complement each other and show a much more complex picture that we see, and it's important that this knowledge exists so that it informs the decision making, because it shows that obviously there are good compliers, and we are very happy to see that states improve in some cases, but also this is a problem that affects really many people in daily lives. It's not a technical issue, and it's important that this message is conveyed consistently across various fora to kind of draw attention, and also really use the existing instruments to follow up with what Daniel was saying, use existing tools and also revisit what is available and learn also across the systems. I've seen a lot of discussion about, for example, Rule 9 and how this could be conveyed and kind of used also in the Luxembourg system to enable civil society to voice independent kind of opinion and input about the state of implementation as well. So I think, yeah, it's important to revisit what works, what doesn't work, and learn from it as well, but also get this message across and highlight that it is a problem that we could learn from each other and try to solve as well as two systems taken together.
All right, thank you very much. It seems that we have some activity online. So we have two messages. One with thank you message for the very interesting presentations. And the question is, did you try, I guess it's addressed to both of you. The question is, did you try to mix both mappings and see whether countries do some ruling shopping depending on the issue at the court? And the second question is a more technical question about the date of the publication of the full report.
I'm not quite sure, because the question is, obviously the rules are different in terms of how cases get to these courts. And for example, individuals don't always have the luxury to choose. They can go to Strasbourg court, but they cannot directly go to the Luxembourg courts, and then they would need to go through the national courts, which are not always willing to refer the cases to the Luxembourg court. So it probably would vary very much in terms of what is the issue involved and where to raise this. But I don't think these are not interstate cases, so I'm not quite sure whether states have a maybe that's a commission that also faces the choice what to take to the court and what not. But probably it varies depending upon the specific situation.
Yeah, I would not have much to add. Also, judging from the Strasbourg court perspective, the respondent state really does not have a choice. It comes before the court, regardless of its willingness, and then it is a matter of, and this is something that we did look into, how similar problems are then present in both jurisdictions, and another step. Further deepening our research, I guess, at a later stage, also in the coming years, we will look into why across some thematics the states have better performance in terms of one member state in one jurisdiction compared to another jurisdiction. We did not go that far this time because there are also limitations. This is a report that already quadrupled in length in 4 years' time. So we will keep tailoring our approach to bring more discussions. As regards the release of the full report, this will come in a few days, and everyone who has subscribed, of course, it will be published on our web pages, but also it will be communicated to everyone who participated in this meeting online or with physical presence.
Yeah, thank you so much. I would also like to comment on this question. I think even if we take out the element how the case goes to the courts, and let's assume that once we have a judgment on the same topic, judgments from the European Court and ruling from the Luxembourg Court, it's still, I think it would be highly impossible to come to, absolute conclusion that there is a ruling shopping depending on the issue, because there might be so many elements and criteria to take into account. So I think that could be almost impossible from, scientific point of view. We have another message, again, a thank you message for both presenters for your time and exploration. It shows a lot of work has been done and still needs to be done on this issue. Yeah, now please, the floor. Yeah.
Thank you. Just a couple of questions. So one directed at Julieta mostly, but obviously Dr. Nina, come in if you want. Julieta, in your presentation, you touched upon robust implementation mechanisms in member states of the Council of Europe. I was wondering, and I think around the examples of Finland and Czechia, if I remember correctly, I was wondering if you could elaborate in terms of what that kind of looks like in terms of a robust implementation mechanism nationally. And then second question, more so for Dr. Nina, I was quite curious in terms of the annual rule of law report that the DG Just has been publishing over the last few years. I was wondering how that has helped or linked in with any of the implementation of the rule of law CJEU judgments that you touched upon, seeing as your presentation focused on rule of law judgments implementation. Thanks.
Thank you very much, Adam. You're joining us from the CJEU unit of the Council of Europe, and I thank you for being here, but also for your question. As regards the strengthening of the national implementation mechanisms, there has recently been, the Council of Europe has recently produced a multi-study exactly on this question, about good practices of how to strengthen national implementation mechanisms. This is an ongoing effort of the Council of Europe, of a variety of cooperation activities in cooperation with member states, and we have contributed together with a list of wonderful experts at national level. We as EAN have contributed at the level of coordination of the findings, but it comes down to this basically. Creating more robust mechanisms means creating mechanisms that have a strong legal basis in the national law. So they have a clear mandate. They are created by virtue of law, and not by secondary legislation. That they have adequate power to coordinate among different authorities that are responsible for adopting the necessary measures. They are well-resourced, well-financed. There's a strong budgets earmarked for implementation purposes and for the robustness of the national implementation mechanism. For me, one element which is very important is the support of the government agents' offices by consultative councils, consultative bodies that help the government agents' office reach better results. So some of the most robust mechanisms, national mechanisms, have such councils created, and these are operative. It's not a tick box exercise. So the coordination authorities, they receive the feedback from a lot of national stakeholders, including civil society, independent bodies, NHRIs, equality bodies, but also at regional level from the judges, etc. So those are some of the elements. And by the way, I spoke about Finland because that was the most recent example, but there have been other such good examples. So Slovenia is another example that we need to acknowledge. This reinforcement did not happen as recently. It had happened a bit back in time, but the good results still hold, and Slovenia has a very, very low number, a one-digit number of judgments pending. So yes, and we need to keep going towards this type of reinforcement of the national mechanisms, because it will not resolve all the problems, but it does resolve some of the problems, and it is important that we continue.
Yes, a few words about the rule of law report. As I mentioned before, the Strasbourg court data is there. The Luxembourg court data is not there in any form. Usually a report refers to things sporadically here and there, depending upon the substance. We would think that the existence of the data is a foundation for subsequent action. So I think it would be helpful for the Commission and coherent in the approach, because if you include Strasbourg, why not include Luxembourg court? Because it's equally problematic in terms of rule of law. So it would be more coherent if they also included the data on the CJEU. The problem is that this data is not so readily available. So then they would need to come up with the system, or maybe their own methodology, or use the civil society data. I think it would be really helpful also to explain why certain states are mentioned in recommendations, sort of they issue recommendations sometimes, for example, to Belgium last year. So it would add to the legitimacy if they had data and they derived the decisions whether to include something in a recommendation or not based on the data, rather than random or kind of selective choice, because otherwise they are really vulnerable to the criticism as to why they chose one country and not the other. So our recommendation would be to make it a metric. Collect data on their own if they want to. They could use our data as well as independently, and then derive conclusions from that. Because if you have the ECtHR data, what does it mean to have it in the report? Does it draw any consequence for those states that don't do well in terms of compliance? So for us, there are these two levels. So essentially have the systemic data on the CJEU, and then from both sets of data derive some sort of consequence, so that to make the recommendations stronger, etc. And so that would be kind of our call in that respect.
Thank you very much, Nino. We have another question online, but it comes from the Jack Hanning, President, Association of School of Political Studies. The question is about Osman Kavala case, which is Turkey, and it falls outside of the scope of the report that we're presenting today. But still, I think I will read the question, because the second part is more general and it concerns the Strasbourg system. So the question is, what can be done to make member states to do what they should be doing, in particular in the light of the Article 46 rulings in this case? In this case, I guess it's still the case of Osman Kavala.
Thank you for this question. It's the $1 million question, of course. We are serving a system, because we are all serving a system, this Strasbourg system, which comes with a great added value. but also with some inherent weaknesses. And the inherent weaknesses come from the setup. Its biggest strength, which is its collaborative nature, and the fact that it is based on the existence of political will to keep things moving forward, becomes its biggest weakness when that political will is not there. This is what sets the Strasbourg system apart from the Luxembourg or Brussels system, the one set up by the EU, where the toolkit is there and it is stronger, it has stronger teeth, but the procedures are lacking. And this is this mismatch is increasingly the question that we are called upon. Also, we see our research services are requested more and more often towards that direction. As regards the Strasbourg court and what can happen, the toolkit at the availability of the Committee of Ministers primarily, but that of other bodies that can influence the trajectory of implementation is well known. It is set indeed out by Article 46 of the Convention, especially with the addition of legal tools at the availability of the Committee of Ministers, but also a body of practice that has developed in the meantime. The problem is that the measures are there as long as the political will to make these soft law tools otherwise is there, it is strong, and it drives the member states. There is no other means of enforcement. The Committee of Ministers has concrete measures. It can use debates, it can use trigger-ups of cases, it can use interim resolutions. At the end of this road, it can use the infringement proceedings. The important thing is, what is the follow-up? What happens if these measures are not respected? This is the current dilemma the Committee of Ministers is finding itself confronted with. I think that we have moved from this prevalence of multilateralism several years ago that kept the system a bit shielded from this kind of problems, towards this distancing from multilateralism and this idea of getting out of the meeting room of the Committee of Ministers when things are discussed, and then touching the problem again 3 months later when we will discuss the case again. It is not as simple as I mentioned it, of course. It's not as schematic as I mentioned it, but what I mean is that we need a completely different involvement of the member states. And this is why I'm happy to have had in this room today also some of the good pupils, good implementation pupils. We need the good pupils to be vocal. We need states to come back to a situation of a clean record, clean implementation record, so they can use this record to entice other people or other states, or to tell them, please do it like we do, because we need to go gradually towards a situation of implementation. But also we need strong individual members that hold up, not just in that meeting room, not just through the decisions coming out of that meeting room, but also when going out, using all means of pressure at their bilateral discussions, also passing the message at all levels, at the bilateral level, at the multilateral level, that there can only be one direction, and that direction can only be the respect of the standards. This is what was making the system work better some years ago, and this is what we need to go back to. We are not there yet. This is our main problem, and this is what we are talking about when we say that the toolkit, the Council of Europe toolkit, is not used as robustly as it could.
Thank you so much, Julieta. On this positive note, I think we can close the event. Oh, there is one more question. If quite quickly, then we will close the event. Thank you.
Yeah, thank you very much for giving me the floor and for organizing this very interesting conference. I have a question in reaction to what you just said, Julieta, which is about the weakness of the system and of the Council of Europe toolkit. But so don't you think it might be an occasion to reflect of using another toolkit, maybe, for example, under public international law, under the law of state responsibility, and other mechanisms that would be outside of the conventional mechanism, which in certain cases, for example, the currencies of the Russian Federation are not efficient, and it's a reflection which is going on even at the level of the Committee of Ministers. So don't you think it could also be an avenue that should be used, like using the mechanism of like also the Vienna Law and the Convention on the Law of Treaty, or like the RCW articles? Thank you very much.
Thank you, Antoine. As per your position within the Public International Law Division of the Council of Europe, you're best placed to ask this question. Indeed, this is where we want to see this situation going towards. One of the solutions would come potentially for such measures. It's some of the most promising, at least, aspirations of people who try to get some individual redress comes from looking up to these kinds of progress or possibilities. I know that these questions are being discussed for at least 3 years now, and there has been no consensus about how we can curb the barriers at the same time, because the public international law also has barriers when it comes to the cooperation between the treaties and how one can be used to help reinforce the other. So I would really love to see these barriers overcome. Another possibility that personally I do not support is the recurring proposal of creating a kind of a toolkit, or enhancing the Council of Europe toolkit with punitive damages or kind of financial sanctions. I know this is supported by many. I do not agree with that because, first of all, we have not seen this type of sanctions working much better at the EU context. It can to a certain extent, but it has not reached helped us reach the desired results either. And secondly, a solution like that would not take adequately account of the sui generis nature of the Council of Europe system, which is based on politics and diplomacy working. So what the Council of Europe says basically, and the convention mechanism says right now, is that if there is money to be spent, let them fund necessary reforms, not fines for non-implementation. And I think it is a wise system. Our failure to uphold the system in its true dimensions, which is the political and diplomatic one, should not be taken as a starting point for thinking other types of measures towards that direction. Let politics and diplomacy work first, because now it is not working, it is not producing the kind of results it should. And then we start talking about finances. Thank you.
Thank you very much for everyone. Thank you for our guests for coming and spending your time in listening to our reports. Thank you. A huge thanks for our speakers for excellent presentations. I guess we can close the event and we will be... Yeah, of course.
Just one thing on my side to thank, because I have not had my eyes on this online, but very many thanks to the colleagues who joined online. In particular, I mentioned the Rule of Law Unit colleagues who were there for your vision, the colleagues from Stiftung Mercator, Mira and your wonderful team for the support, unequivocal support, but also the team in Berlin. We have Nino with us, but Nino has been part of a great team, including Jakub, Dennis, Albert, Emilia, Federica, and of course managed by Mr. Paul Zubkov. Hi, Paul. And last but not least, a very big thanks to my own fabulous team, Furkat, Vincent, Joanna, who is not here with us today, but thank you for working miracles and for keeping the EIN vehicle going so well.
Thank you. So let's wrap up this event and meet outside, Vincent, to what do we have, coffee or wine to share? And please, those who hasn't signed the list of attendance, please do it. We would very much appreciate. Thank you.